Hello and welcome to Absolute Trust Talk. I am Kirsten Howe and here with Madison Gunn. This is our live Facebook, etc. version of our podcast, Absolute Trust Talk, here at Absolute Trust Counsel. Madison, most people who will be watching this will be, a week or more after we're actually recording it, but I feel I have to acknowledge what's been happening in our world. We are here today on a day where it's actually sunny and not raining, which is unusual for this past week or two. We've had a heck of a lot of rain. Have you had any damage at your house?
No damage, a little bit of flooding coming into the garage a little bit. We have a downspout pretty close, but no actual damage, thankfully.
Okay.
Which,
Yeah, me too. Yeah. But
if we did, we have a basement, so it'll go there first.
We have a basement, which normally gets wet if it rains a lot, just like wet.
Yeah.
But this storm system, I actually saw standing water down there, like in about an inch deep. And that's the first time I've ever seen that.
Yeah. I've only seen that when we've had our water heater go out.
That's a whole other.
Yeah, that's a different kind of flood.
But
we're supposed to get a bunch more. So
I know we're not done.
It looks like a hurricane off the coast.
Yeah, it's bad.
It's crazy.
But I feel like we've been lucky. It really hit the North Bay hard and the South Bay and kind of missed us, or didn't punish us quite as much. So we can be great.
The thunder was fun, but I'm glad there was no damage. Although it's interesting watching them clean up like Santa Cruz now. Those before and afters were crazy.
That was ugly down there. Yeah. Anyway, so okay, we got that out of the way. Today, what we're here to talk about is Prop 19. Prop 19 has been around for a couple of years. The California voters, just to remind our listeners, passed Prop 19, which is a constitutional amendment. A couple of years ago, it became effective. And it was a big deal at the time. And now we've had a few years to see how it has rolled out a little bit. And we've had clients with experience with it, and we've seen some new things. And also the Board of Equalization, which is the overarching governing body relating to property taxes, has issued some guidance. When Prop 19 first, it was just, a ballot proposition, and it said what it said, and it didn't link up with what happens in the property tax world. So there was a lot of questions, and now we have a few more answers. So that's what we're going to talk about today. So Madison, why don't we start just by kind of recapping the two parts of Prop 19?
Yeah. So there's a good part and what most of our clients would consider to be a bad part, and that people are still quite enraged about and not sure what happened. The good part is if you're over 55 or a natural disaster victim, you can transfer your property tax base from your existing home to a new home. And it doesn't matter what county you're moving from or to. There used to be able to do that with limitation, but now it's all 58 counties. And it used to be you could only transfer to the new home could only be of equal or lesser value than the existing home. Now you can get a replacement property of higher value. There'd just be a partial reassessment. So, if you own your home and it's worth $500,000, but you're only taxed on the assessed value of $100,000, you could turn around and buy another $500,000 home, a brand new one in any county in California, and still pay the property taxes on $100,000. So then obviously that can be adjusted depending on, the property taxes in those counties, but whether it would go up or down.
Yeah, that is pretty much across the board a good thing. Everybody was happy about that.
Yes, and you can do that up to 3 times.
In your lifetime, yeah.
Yes. And then the bad part is that...
the part that we have to deal with,
is that previously, before February 16th, 2021, if you died or transferred property to your children under Prop 58, you could transfer your primary residence or the family home and up to $1 million in assessed value property of any kind to your children without any reassessment. The Prop 19 has eliminated the extra $1 million in assessed value, and you can only transfer the family home, and you only get $1 million extra in assessed value. So it can't be more than that, or you have to get a partial reassessment. And it has to be your primary residence, and then one of your children has to move into it and make it their primary residence within a year after the transfer. And then if they move out, the property taxes go back up.
Yeah.
So you only get it while you're living there.
So the only thing left of the parent-child exclusion, which used to cover a lot of things, it used to, rental properties, commercial property, vacation homes, it used to cover a lot. And now the parent-child exclusion only covers the primary residence or family home, whatever you want to call it, if that's transferred to a child and the child makes it their primary residence. Yeah. That's it.
And only for as long as it's their primary residence.
For as long as it's their primary residence, yeah. And everything else is going to be reassessed. And that still to this day surprises clients when they come in.
Yes.
We talk about it in planning, and then we have to talk about it to the kids who have now inherited property. And we have to explain to them, okay, this is how it's going to work. And there's still, people are surprised. They don't, it didn't get enough.
Well, yeah, to be fair, when it was being marketed as the ballot proposition, that was not mentioned at all. The parent-child exclusion was not mentioned at all. It was all about those wildfire victims getting to transfer their property tax base.
Yeah.
And to be fair, they'd always been allowed to do that. So this didn't change that. So it was just creative marketing on behalf of the people who
really wanted it to pass.
Who are pouring their money into the marketing.
Yeah.
So
okay, that's how it is. We can't fix it, but let's talk about the things that we now know that we didn't necessarily know back in February of 2021. First of all, the easy one, there's new forms.
Yes, you have to make sure that whatever the transfer date is, that the form matches it. So if it was a transfer before February 16th, 2021, you use the old forms. And if it's February 16th or later, you use the new forms. And they will kick that back and deny it if you don't use the proper form.
Yeah, and those forms are, they weren't available to us
right away.
It took them a while. The Board of Equalization, it took them a while to amend their forms, and that's fine. So now we have new forms. Just make sure you use the correct form. All right. So, but we also have actual clarifications from Board of Equalization. Let's talk about the bridge loan, which is one of Madison's favorite topics. We've talked about this numerous times.
Yeah. So before Prop 19, if you had multiple children inheriting a home, and if children were to buy each other out, sibling to sibling, there would be a reassessment, right? There's no sibling to sibling exclusion. So what most people would do, or what they could do, what the BOE had previously allowed, is to do a bridge loan, which is a loan to the irrevocable trust so that there's cash in order to support the buyout without being a sibling to sibling transfer. And then the sibling who's taking the house takes it subject to a mortgage to offset their siblings. The BOE has clarified that Prop 19 did not change that. So if you're leaving your house to your 3 children and one of them wants to move in and make it their primary residence and the other 2 don't want the house, they could do a bridge loan to take care of that, provided that the child inheriting the house can afford and qualify for a mortgage on the house.
Right. So that fix of it's a house, there's 3 kids inheriting it, 1 wants it, 2 don't. There is still that fix available. Yeah. Prop 19 didn't change any of that. Okay. So just as a reminder, and this is not new, but there's BOE, guidance on this. This is not new, but when a parent dies, The date of the transfer is the date of death. It's not the date that the trustee gets around to distributing the home to the children. It's the date of death. So if the taxes are going to go up, they go up effective on the parent's date of death.
Yeah.
And that's not new, but people need to know.
Well, yeah. I mean, if it takes them 2 or 3 years to do the trust administration, don't be surprised if there's a supplemental tax bill
Right.
for that previous 2 or 3 years. So,
Right.
I mean, that should be prepared for.
Yeah, you have to anticipate that that's going to happen. Okay. And so now this is something that we didn't know, and the BOE is now telling us about the child. If a child wants to make it their family home, what are the time limits on that?
Yes, they have to make it their home within 1 year of the date of death. And how you make it your home is to file a homeowner's exemption form. That is now available online. It didn't used to be. You used to have to call your local assessor and have it sent to you. In order for it to be considered your parents' family home, they have to have had a homeowner's exemption filed on the property, which reduces your assessed value by $7,000 or saves you $70 a year on your taxes. And then the child who plans to move in and make it their family home has to file one of those documents within 1 year. And essentially, you're signing under penalty of perjury in California that it is your primary residence. And it's different than the parent-child exclusion form, which is entirely separate. This is just showing that it's your primary residence. So it's gone from one form to a lot of moving parts
Right.
under the Prop 19.
There's a lot you have to do to get that property tax assessment transferred to the child. There are multiple forms you've got to submit. So the parent-child exclusion form is where you're actually saying to the assessor, don't reassess, don't raise my property taxes because this was a parent-child transfer. And in support of that, you have to have filed, or you have to file that homeowner's exemption.
Yeah. And typically the parent-child exclusion form is much longer, and you have to produce a copy of the trust if it's through a trust administration. You used to have to show all prior transfers, but now that you only get, it's a one and done with the primary residence, you don't have to do that anymore, but you still have to provide a copy of the trust if that's how it was submitted.
Right. Right. Okay. Okay. So now we have, this is not infrequent that the parents' trust says, I leave everything equally to my 3 children. And there's basically a home and maybe a couple of bank accounts. So what the BOE has said is that the children they could inherit it and keep it. They could be co-owners of the house, and they can still get the parent-child exclusion if one of the children who is a co-owner moves into the house and makes it their primary residence.
Yeah.
Again, within a year.
Yes.
And then what happens if they move out?
If they move out, then the property taxes are going to be reassessed, or they will go up to a new assessed value. And it will go back to the date of death. So it's not like if mom dies January 1st and you move in and 2 years later you move out, it's going to go back to that value from 2 years prior. So if it's gone up a crazy amount in value, it's still going to go back to the date of death, and it will be indexed for inflation, which under Prop 13 is still limited to 2% a year.
2% a year at most.
Yeah. So it's not going to be the current value.
Right. But what could also happen is one child moves out and another child moves in.
Yeah. It can be the rotating family home.
Yeah. You can preserve that parent-child exclusion as long as it's some co-owner's primary residence.
Yeah.
And they got to move in within a year of the other one moving out. Am I right? Something like that?
I think so. Yeah. As long as it's within the same year, I think that's fine. Okay.
So, so this is kind of creating a little bit of planning opportunity for our post-death children, family.
it's definitely something to think about. And as we've espoused many a time before, it's that family conversation that should be had about the family home, so that, having to uproot your life and move into the family home that's probably been lived in for 50 years that's a big project. So, conversing about it beforehand is probably a good idea.
If you can. Yeah.
Yeah.
Yeah. It's always talking about things ahead of time is better than not.
Yes.
Sometimes it's just not really possible. Okay. So now nothing has changed. The BOE has made this clear about trusts and life estates. So I'm just going to give a little hypothetical, like mother, she leaves her house in trust for the benefit of someone who's not a child, could be a step parent.
Yeah, her boyfriend.
Could be her boyfriend, in trust for that person's life. And then when that person's life is over, to the kids. So during the time period where it's in trust for step parent or boyfriend or whomever, that's a situation where, well, if it's step parent, no, but let's say it's a boyfriend, there will be a reassessment, right?
Yes. So it would reassess because that is not an excluded or an
no
exempt
excluded
transfer.
Yeah. If it was step parent, that's where I'm pulling back. If it's step parent, there's a spousal. Yeah. But if it's boyfriend or cousin, whatever, there would be a
reassessment at the date of death. And then after the life estate, what happens?
So after the life estate, now the transfer is being considered a transfer from mom to children, because it's still mom's trust and it's going to children. So now the parent-child exclusion will apply. But if the trust is written correctly. So
the taxes would go up while the boyfriend is living there, and then they would go back down once the parent-child exclusion is approved.
They would go back down to where they were when mom was living there. Again, adjusted for the maximum 2% a year.
I would like to see how quick that happens.
How quickly they put it back down?
Yes.
Yeah. They're going to raise it quickly, but
yeah.
How quickly?
A lot of this is, we have guidance from the BOE, but there's still we get a lot of questions from clients where we're like, I don't know. That's a risk you take and we won't know. You can always write a letter to them and ask for guidance ahead of time to ask permission rather than beg forgiveness on the back end if they reassess your property.
Yeah.
But, we're assuming they're going to do what they say they do.
Yeah. And then, if it takes them a little bit of time to lower that assessment, you still pay your property tax bill. You pay whatever the bill is, and then you go chasing after the refund.
Yeah. Something to consider in the land of, if you're going from $4,000 a year to $24,000 a year, that somebody's going to have to front that $24,000 a year until it drops back down.
Right. Yeah. And that's a lot.
Yeah.
And we have families with that problem happening, and that's got to be worked out. Okay. So now I'm not sure if this is different. Well, I think it's a little bit different, but there's actually BOE guidance on this issue that if the parent's primary residence family home is a unit in an apartment building that has multiple units, the parent-child exclusion is only going to apply to that one unit. And the rest of the apartment building is going to be reassessed unless there's some other exclusion that applies to it.
Yeah. So that applies to an apartment building, a duplex, a fourplex,
right?
Things like that. What it doesn't apply to is if you have your home and then it has an accessory dwelling unit or an ADU or an in-law unit or a granny unit, whatever you want to call it, as long as it's all on the same deed, it's one property, it's not a divisible property, then that will be allowed. Meaning, if you inherit the property and you want to live in the ADU and rent the house out, it's still your primary residence and it still qualifies. And that also applies to the base transfer of your taxes. So if you're selling your house and buying a new one and want to, go in with your kids and, buy the house and live in the granny unit while your kids live in the main house, you can still transfer your tax basis that way.
Okay. So that's interesting. That seems like there definitely is a policy push behind encouraging people to build ADUs and I guess that's the difference between a duplex or a fourplex and a house with an ADU is the policy considerations.
They're looking at multi-generational housing on one property as opposed to a commercial investment property.
Yeah.
Because it used to be that you could own a duplex and rent one out and live in one and get the whole
whole thing,
get the whole shebang. And now that's not the case. They're trying to limit the transfer of investment properties.
Right. And encourage the multi-generational stuff for a variety of reasons. Okay. So the parent-child exclusion, we were talking about the base year transfer, which is the 55 and older and wildfire victim transfer part of Prop 19. You can only do that 3 times. Is that what you said?
Yes, in your lifetime.
But the parent-child exclusion, that's not true. You can do it as many times as you can figure out how to make that work.
Yeah.
But you're limited because it's only the primary residence to primary residence. And so there's a lot of people moving around. If everyone lives with their parents, it's not as complicated, but most likely that's not the case. So that makes it more difficult. Right. Okay. Now, one thing about Prop 19 that wasn't true before when we were under Prop 58 is there's a cap of $1 million. You want to talk about that a little bit?
Yeah. So essentially, you get to keep your property tax base, but only so far as it hasn't gone up more than $1 million. So, if your house, if the assessed value is $200,000 and it's worth $2 million, you only get $1 million of exemption. So you take that, $2 million, you minus the million and the 200,000, and you have the extra 800,000 that you do have to pay taxes on. So that 800,000 is added back on. Essentially, I like to say, take the taxes for the whole thing. When you look at your tax bill and it has the assessed value, just subtract $1 million off of it, and then that's going to be your new assessed value. That's a lot easier. That's a lot easier than the way the BOE explained it in the bill, where you subtract it and add it back in. You're like, well, it always adds up to $1 million. So why don't they just subtract $1 million? I mean, if you look at it and you filed the homeowner's exemption, you see the assessed value and you subtract the $7,000 for the homeowner's exemption. You're also going to see essentially subtracting $1 million. $1
million. Yeah.
And then that's your taxes. So it's 1% plus the other local taxes that are added on, usually no more than 0.1%.
Yeah. It used to be under Prop 58, the parent-child exclusion applied to the primary residence, unlimited. Didn't matter how much it was worth. Now they're capping that at $1 million and the rest will get reassessed. But they are also, this clarification from the BOE is that number, $1 million, that's going to go up every year. Indexed to some inflation number, not the 2%, some federal housing number. So, it won't be $1 million. I think that's starting this year, starting in February 2023. Yeah. Every year it'll go up a little bit.
Yeah.
Presumably, I don't think we've ever had deflation, at least not in
the housing market.
30s, not since the 30s, or maybe in 2008, maybe we did.
Yeah. Well, yes, I had a reassessment of my home and the property taxes went down.
Yeah, so. I did too. but then they kicked it right back up.
Yeah, that's true.
First opportunity.
Yeah.
Okay. Anything else you want to say about that, Madison?
No, I mean, the $1 million is nothing to balk at. I mean, if you're going from 4,000 to potentially 24,000, and that lowers it to maybe 10,000, that's a lot more manageable.
Yeah.
An extra 6,000 versus 20,000 is a little bit more manageable.
Yeah. It could make the difference between, we keep the home in the family, or we're forced to sell it because nobody can pay those taxes.
Yeah.
Which is, unfortunate. Let's see. I'm looking now back through questions and make sure I get all of them. I do have one question. Okay. There's a lot in there. All right. So if two siblings inherit the parents' family home, one of them makes it their family home, can the one who lives there pay rent to the one who doesn't live there? Well, yeah, you can. Yeah. I mean, that's a different tax issue, right? That's an income tax issue, not a...
Yeah, and we have a show where we talked about that. So where you have multiple children inheriting a house and the problems that may arise from that.
Yeah. So, yeah, the one who lives there can and should pay rent to the other ones unless they work out and they got to work it out. That's law and drama from the family. But yes. So the answer, yes. Okay. I'm seeing that there's a new comment that I might not have seen, and let me just make sure it's not a question that I should be answering. Nope. Okay. I think that's it. I think we did it. And Madison's had a bit of a cough, but she made it through the whole episode without coughing. So yay!
The win.
That is a win. All right. Thanks, Madison. It's always fun to talk to you. And thank you all for watching and listening. We appreciate you as viewers and listeners, and we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.